Okay, we will call to order the Wednesday, February 7th, 2024 regular meeting of the Aspen Pitkin County Housing Authority. First item on the agenda is the roll call. Cindy?
Kelly? Can we hear you?
It's very quiet.
This is turned all the way up. So, Peter? No, we can't hear anybody.
It sounds like they can hear us. We can't hear them.
Great. This is just wonderful.
We can't hear them.
Should I just keep talking
There we go.
until you can hear me?
Gotcha.
There we go.
There
We
we
got
go.
you.
Are you present?
Okay, great.
Can you hear us?
Can you hear us, Kelly? Yes.
Yes.
Okay, great. So Kelly's here.
Kelly said here.
Yep.
Peter?
I'm here, present.
Thank you.
Yay.
Carson?
Here.
Ward?
Here.
And John?
Here.
All
Thank
right. We will move. Are there any requested agenda amendments? Hearing none, we'll move to public comment. Is there any public comment? See Jennifer Fulton. Hi, Jennifer. Welcome. So for public comment, we hold our public comments to a 3-minute time limit. So go ahead.
I shouldn't surpass that. I just want to thank everybody for their cooperation and facilitation for the Right Size program. I'm happy to say that we successfully closed and moved in about 2 weeks ago, and both parties are really happy. We just love our new place, and unfortunately, Jim is driving the bus today. He couldn't make this, but wanted me to thank you guys as well. It was really successful for us.
Great. Well, thanks for the comments. I mean, I think this is a win. We've gotten a property that otherwise might not have turned over, and we have put a family into it, and I hope it is the first of many.
I agree. Thank you so much, you guys.
Great.
Any other public comment? All right. Hearing none, we will move to Board of Directors comments. We will start on Zoom. And Kelly. All right, we'll come back to Kelly. Oh, no, there we go. Kelly, go ahead.
Hi, slow to get off mute here. I don't have any at the moment. Thank you.
Thank you. Peter?
I have no comments other than I appreciated watching the council work session where John and Ward presented to the rest of the council, and thank you for doing that, and look forward to following up on that, just having more discussion.
Thanks, Peter.
Thank you, Peter. John?
No comments tonight, thanks.
Ward?
I'm following in Kelly and John's example. No comment.
All right. Well, I'll keep it going as well. So we'll move to the executive director comments and a staff update.
Good afternoon, everyone. I just have a few things. I'm Matthew Gillen, the executive director. The RFP for the HOA reserve studies was approved by resolution by the council. Thank you for that. So we are moving forward with that. We're also talking to our friends at CORE. They may be able to add to that contract for some energy audits as well, which would be great. And then council will also be looking next week at changes to the Essential Repairs Grant Pilot Program, which will be on the consent calendar. Our colleagues at the county, they felt they didn't have to do it that formally, so we've informed them, but they're fine with it. So you guys will have that in your packet next week, so thank you for that. And we are still working hard on the electronic solution to the tax returns, the tax transcript, but I just want to assure you we're still working on that to make sure we have a good process which doesn't slow down approvals. And then Maddie, we don't have a baby yet, but Maddie is on maternity leave. So Cindy and Bethany are taking over qualifications while she's on maternity leave. So one way or other, there'll be a baby this week.
All right.
And that's it.
Okay, Cindy.
We have advertised some rental units, so please check our website. And we continue to add ownership units, and we actually have a few. We're doing 2 lotteries to finish up the last 5 units at Burlingame. There are 4 Category 4 3-bedrooms and 1 Category 3 3-bedroom. So if you're interested, make sure you check our website. Thank you.
Thanks, Cindy. I see we've got a hand up from iPhone. I'm not sure who that is. Whoever's the iPhone on Zoom, do you want to?
Sorry, Carson, it's Diane. I couldn't get on.
Oh, hey, Diane.
Sorry, I'm on my iPhone. Sorry about that. Hey, Matthew, I just realized we've been going back and forth all day about Monday's agenda. Do you want to give the board a heads up, or I can if you'd prefer?
Go ahead, Diane. Thank you.
This coming Monday, there's a joint meeting of the City Council and the BOCC. It will be at 4 p.m. in City Council chambers. And one of the topics, there are a bunch of topics on that agenda. One of the discussion topics is, one of the agenda items is discussion of APCHA policies, and that will be led by Ward Houndstein. And so I just wanted to give you all a heads up. Matthew will be sending you all a notice of the meeting. It isn't technically a quorum because, at most there'll be the 4 electeds in that discussion. However, it's a public meeting, so if we're going to notice it as a possible quorum, because if others want to come watch, or you can. So just wanted to let you know that you all know that was happening. Thanks.
Thank you, Diane. Okay, we will move. Next item on the agenda is the consent calendar. The sole item are the minutes of the January 17th, 2024 regular meeting. Are there any amendments or a motion to approve or discussion?
I move we approve the minutes of the last meeting.
Okay, I have a motion from Ward,
Second.
a second from Kelly, and it is a roll call vote.
Okay. Kelly?
Yes.
Peter?
Yes.
Carson?
Yes.
Ward?
Yes.
Thank you.
Okay, motion is approved. Okay, next item on the agenda is Miriam Silvino's appeal to the APCHA Board appealing the hearing officer's written decision regarding Miriam Silvino dated November 2nd, 2023, affirming the notice of violation dated August 31st, 2023. Before we begin, I just have a statement to read from Allison Bektesh, who is absent today, and this is Allison's statement. I have a professional relationship with the appellant. She has been a coach of mine through the Aspen Snowmass Local Women's Clinic for years. While her housing status has not come up during our interactions and we have not discussed details of this case, I am recusing myself from this hearing so as to assure the public that there is no conflict of interest within APCHA's judicial matters, end quote. So just wanted to read that. With that, if you want to come on up. So just quickly here, just from a procedural standpoint, I'll just kind of run through. So with the appeal, the way that we'll be handling this, we'll have 30 minutes for the appellant, 30 minutes for staff, and once time has expired, the board will deliberate. The board is hearing the appeal of a decision made by the hearing officer. As such, evidence which was not presented to the hearing officer will not be admissible. The appellant will go first and may reserve part of their 30 minutes for rebuttal. and I can let you know 10 minutes or whenever you want.
That'd be great.
I'll let you know when you've got about 10 minutes left. And then lastly, just expected that all parties act with civility, integrity, honesty, candor, fairness, trust, respect, dignity, and courtesy. And I will recognize all parties prior to speaking, and neither staff nor the appellant or their counsel will interrupt the time afforded to the other party. So with that, if you want to go ahead and identify yourself. Kelly. Oh, we got Kelly. Sorry, Kelly, couldn't see on Zoom. Go ahead.
No, that's okay. I have a procedural question because I know on the agenda that we have an executive session also noticed. Is that just a place saver in case we want to get counsel from Tom?
Correct. So at the conclusion of
Okay.
the time for each side, prior to deliberation, if the board so chooses, the board may go into executive session if we feel that we need to receive legal advice from Tom.
I will probably request that.
Okay,
And just,
very good. Anything? Go ahead.
yeah, thank you all. My name's Alan Feldman. I'm a local lawyer here for a long time, and I'm here representing Miriam Silvino. Before we get into it, all the appeals I've done, there's always questions from the judges. Should I be expecting that or kind of factoring that into my internal clock, or is it typically just no questions, just?
The board is, I would say, Alan, handle it the way you would an appeal in the Court of Appeals. The board may or may not have questions for you, but
Okay, sure.
it's part of the time you get, just for both sides.
Okay, sure. All right, so I'm here representing Mimi. Mimi is a longtime local. She's lived here since 2008. She was recruited here by the ski company while she was a snowboard instructor down in Portia. She's been a snowboard instructor for 23 years and is top tier at SkiCo. And think she's particularly handy when there are difficult clients. I think Mimi is the one they rely on when things are getting kind of sticky out there. In addition, she's a massage therapist, and she works for numerous spas and has for a very long time, all through Aspen and Snowmass. She does acupuncture as well. She's working on her licensure for that. She does a number of other healing arts, and she's trained for years doing this. She works for several local spas, as I said, works with local caterers as well because she likes to cook. And she's lived comfortably, without conflict, in APCHA properties for years before she moved into Williams Way. There is no question, none, that Mimi does not qualify to live in APCHA. That has never been raised. It is not a subject of the appeal. It is to an extent of my argument, but it was never the subject of any notice of violation. APCHA has never held Mimi in violation of any APCHA regulation at any time. Mimi's not the subject of the notice of violation, which has brought us here today. The subject of the notice of violation is John Francis, Mimi's ex-husband. And we'll talk about that a little bit later. Now, Mimi and John got married in 2022. And Mimi moved in to 401 Williams Way, which has been owned by John. And there may be a typo in my brief. I believe it's 2002, but it may be 2005 when he first took ownership of that unit. So he's owned it forever. So they get married. Mimi gets on title with him. Within 10 months after Mimi's ownership in 2022, APCHA's requiring Mimi to fill out a biennial ownership application. My understanding of the rules, maybe I'm wrong, is that those biennial affidavits are issued every 2 years, and you use a series of pull-down menus. There's not much room to do anything on that form online to answer some questions about what happened in the past. It's looking backwards instead of looking forwards. I don't know why Mimi was required to do that, but let's just put that aside for now. And APCHA issued a notice of investigation to Mimi in early August 7, 2023. And APCHA requested a bunch of documents. Mimi promptly delivered to APCHA reams of documents in response to their request. That was the last time that Mimi ever heard from APCHA about her qualifications, is when APCHA issued the notice of investigation. That was the last time. Mimi provided the documents. 2 weeks later, approximately, APCHA issued its notice of violation. That notice of violation was not, although it was addressed to Mimi, the two alleged violations were exclusively addressed to John Francis. Let's give a background of what happened here. Mimi and John fell in love in 2021. They got married in 22. A couple of months after they got married, things took a real dramatic turn in the household. John became very violent, scared Mimi to death. She had no idea this was coming. She certainly didn't plan on it. For some reason, APCHA staff seems to think that this whole marriage was a scam for Mimi to backdoor herself into another APCHA property from the one she was already living in. It's not the case. They got married. Mimi didn't really know John. John's got a lengthy criminal history. John became very violent. Mimi filed for divorce. John agreed and signed the papers, and promptly after that took off on a boat. And it's not just it's a $100,000 boat, right? And that was Mimi and John's, and left for parts unknown. No one's heard or seen from the guy in a long time. So John's never appeared before APCHA or before the hearing officer. And the hearing officer took note of that at the first day in September, where he made some comments that they're on the transcript regarding, hey, look, I don't have, John Francis is entitled to some due process. He's certainly entitled to it. He's not here. Mr. Island was, not sure whether he could issue a ruling. So a strange thing happened then, contemporaneously with that, is that Mr. Island, on his own, completely switched the focus of the notice investigation and the notice of violation, from Mr. Francis's violations to Mimi's. At the hearing, with no notice to Mimi that this was happening. So that's a pretty significant constitutional due process and equal protection violation. Why did, Mick do this? I'm sorry if I say Mick. I've known him for so long. I might slip up. Okay. Why did Mr. Island do this? Well, he realized, I think, that his hands were tied because Mr. Francis wasn't there, and for some reason, Mr. Island just was dead set on investigating Mimi. He lost his way. A hearing officer is not an investigator. A hearing officer is supposed to be an impartial neutral. APCHA presents their case, Mimi presents her case, and the hearing officer rules. That is absolutely not what happened here. It's clear from the record, and the transcript in particular, that Mr. Island took on the role of not only a prosecutor, but he actually took on the role of leading APCHA as the captain of the prosecution team. I mean, it's on the record. You see, he asked APCHA staff to jump onto his private Colorado court ISIS, it's called, the electronic filing system. You have to be a lawyer to get on that usually. He provided his credentials to APCHA staff to go dig into Mimi's divorce proceeding. It was surprising at what was happening. And at the hearing as well, Mr. Island was demanding that Mimi deliver to him additional documents in support of her position that she qualified. Everybody knows here that Mimi qualified in 2022. That's how she got onto the deed with Mr. Francis. Mimi's qualifications were not at issue. That wasn't enough for Mr. Island. He called that whole qualification process into question. And it's in my brief, and I hope you had a chance to read the brief because I spent a lot of time on it. And
So did we.
yeah, thank you so much. I appreciate you saying that. Okay. You know, Ms. Christensen was on the record saying her qualifications were never in question. That wasn't good enough for Mr. Island. He even said on the record, oh, that must be artificial intelligence that made the mistake. He actually changed the hearing from the two topics in the notice of violation to trying to requalify Mimi from day one. He requested 3 years of tax information, which I don't think APCHA is entitled to 3 years of tax information. I'm pretty sure APCHA is not entitled to Mimi's court records, her prenuptial agreement, her email communications with her husband. But yet, Mr. Island was dead set on getting all these things. It was like an inquisition. And, you know, you mentioned something, Mr. Hallenstein, about maybe listening or reading the transcripts. There was a tone there. You know, I have a history with Mr. Island. Right? Years and years ago, he took that tone with one of my clients in a situation that was so egregious, it was over the top. I've forgotten about it long ago. The client committed suicide. So I'm a little sensitive when Mr. Island starts bullying, interrupting, making rude racial remarks to my client, changing the entire notice of violation and the entire hearing into his own personal court where he is the judge, the jury, the prosecutor, and the executioner. It's a big problem for me. And so, yes, it did get heated. So, APCHA, in its brief to the board here, realized that there was a problem with how Mr. Island switched the focus from John's violations to Mimi's, right? On two separate sections in the beginning of APCHA's brief, it says that I opened the door, quote unquote, to Mimi's qualifications. Yeah, it's an intellectually dishonest argument, right? Because that occurred in the September hearing, and I wasn't hired till after the September hearing. I'm not sure why APCHA staff wants to do that. It's intellectually dishonest. It just seemed to me, and it seems to Mimi, that APCHA is going at lengths to try and kick her out. It doesn't seem like they're trying to, you know, right a wrong. It seems like they're dead set on winning, and they're going to do anything they can possibly do to get there. And, you know, you've seen my brief. I don't have to highlight some of the problems, right? But, you know, APCHA staff changed the language in the notice of the recital to the deed restriction in the notice of violation. Right? Changed buyers to owners or owners to buyers. That's not a typo. That's just a mistake. That's just intentional, rather. APCHA staff ignoring Mr. Ireland when he changed the entire scope of the hearing. APCHA should have been, oh, time out. Well, I'm sorry we got sidetracked into that, but we're really here about whether or not, as an aside, everybody knows John Francis is gone, okay? The issue here is whether or not the recital to the deed restriction is enforceable. That's the issue, okay? APCHA should have said, hey, look, I'm sorry, this is going well outside of the four corners of the notice of violation, and we shouldn't be discussing it. No. APCHA co-opted that argument that Mick raised himself, Mr. Island raised himself, and then ran with it, and still runs with it. This is not right. You know, APCHA staff bluntly told Mimi, we're not losing this case. seems more about winning than doing what's right or fair. And, APCHA is suffering from a bit of a PR problem, and I can see that. I don't know what your all's collective opinions is of it, but it certainly seems that way to me from reading, things in the newspaper, letters. I mean, this kind of action, to me, it's in line with bad press. It seems like nothing APCHA should want to be involved with anymore. If it's job or you value, having a good public face. APCHA says in its brief that Mimi understood the terms of the recital and the deed restriction, so therefore, ergo, it's enforceable. That's obviously not a correct statement of the law. It's also, it doesn't make any sense. No one gets married. Everybody who gets married thinks it's going to last forever. They don't think it's only going to last 5 years, and they only have to stay 5 years together. And this 5-year time period is completely arbitrary. It appears nowhere in any regulation. And the regulations that we're discussing are the 2021 regulations, not the 2023 regulations that are in APCHA's brief. So let's go on to this recital. There's a recital that requires John and Mimi to cohabitate for 5 years. That is void as against public policy. You cannot force people to cohabitate or lose their housing. I've argued this in my brief. It is particularly horrible when you consider some of the examples that I gave you in my brief, including Mimi's. She's married to a guy who becomes really violent, and she's forced to decide, well, geez, if I file for divorce, I'm going to lose my housing. That's void as against public policy. But even before we get to whether or not the recital is void against public policy, unconscionable, inhumane, first we understand, what are we talking about here? We're talking about a recital, okay? And I say this in my brief, I spell it out, and I give you some law on it, actual law. APCHA citations in their brief to legal cases are irrelevant, and they're miscited. A recital is not an enforceable term. It's what they call a scene setter, right? It says, Mr. Doyle wants to buy Mr. Schmidt's car. Mr. Schmidt would like to buy Mr. Doyle's, would like to sell his car to Mr. Doyle. Therefore, in consideration of the mutual promises, here's the contract for sale. The recitals are scene setters. They're not enforceable terms. It is not an enforceable term. You can't go to court and say enforce a recital. The court won't have it. Yep. I just wrote this in my, it's a good example. Let's say two guys, are joint tenants on a condo in Centennial, 2-bedroom, right? And then, let's take this deed restriction in its place. In the fourth year, on the second month of the fourth year, one of the roommates tries to kill the other guy, right? And he gets arrested and is in prison. Under the terms of this recital, the victim must sell that house. That's inhumane. It doesn't make any common sense, and I don't believe it's a legal argument that APCHA wants to go ahead and fight. I don't see it. I talked about Mr. Ryland demanding tax records from Mimi at the hearing, despite the fact that Mimi previously provided APCHA with all her tax records, and APCHA qualified her, and there was never any problem. That wasn't good enough for Mr. Ireland. Before I go on to the last section here, it just seems to be in violation of common sense that Mr. Ireland is a hearing officer for APCHA. I mean, he lives in APCHA. He's been called out on his law office being in APCHA. He helped build APCHA. Before and while and during his term as a mayor, he's written how many articles, opinion pieces in the newspapers in support of APCHA. It defies common sense to me that APCHA would think that he is a neutral. Why would he agree to do anything that may at all jeopardize his housing? It doesn't make any sense why you've picked him to be a hearing officer. I can't make heads or tails of it. He was conflicted and acting partisan from day one in the proceeding all the way up to the end of his ruling. He wasn't a neutral. He was actively prosecuting Mimi. And when APCHA's staff wouldn't do something for him, he did it himself. It's clear as day. My brief goes into a lot of it. You know, APCHA went to long, there's a lot in APCHA's brief about, Mr. Ireland's, why he's not conflicted. And they cite the Colorado Springs case for district court in support of an argument. That case has nothing to do with it. That must have been an AI generated legal research thing. The case is not relevant to anything involved here. And then they bring up the Meyerstein case, which you probably all remember. I certainly remember it. That had nothing to do with whether or not a hearing officer can conduct his own investigation. That had to deal with whether APCHA can conduct an investigation, not APCHA's hearing officer. Mr. Ireland led the investigation in Mimi. It's clear. And then, how are we doing on time, Carson?
10.5 minutes.
About 10 minutes left, as I said.
Okay, perfect. All right, so I'll reserve the rest of my time. But my last argument, it's the last argument in my brief, and it's significant. Mr. Ireland issues a ruling, right? And his ruling at the end pulls back all the curtains, showing that he's clearly working for APCHA. It's just irrefutable. He says, look, I'm going to double the fines, right? Because in the notice of violation, the fines weren't for each person. The fines were jointly, okay? I'm going to double the fines, and you have to sell your house. But if you agree to sell your house by a certain date in November, I'll reduce my fines. And you also have to agree not to appeal my order. That is, without any doubt whatsoever, an argument that APCHA would make, not an independent hearing officer. There is no question in my mind that I cannot understand why he would think that is remotely reasonable or proper. It seems that, Mr. Ireland may be losing it a little bit, right? Because that is ridiculous. He can't do that. A judge, a jury, there's a judgment issued. Then the parties work to settle it and maybe give each other breaks. Selling an appellate right is one of them. Give me 25% off that judgment and I won't appeal it. There you go. That's a negotiation between the parties to a lawsuit, not between the judge and one of the parties. It proves without any shadow of a doubt that Mick Ireland was working for APCHA through this whole thing. Thank you so much, and I'll reserve the rest of my time for rebuttal.
So I've got 8.5 minutes remaining. All right. Who's going to take it for staff here?
In the hallway.
Okay. Please go ahead.
I'm Jackie Marinero. I represent APCHA in this matter. And I think first what we will do is we will address some of the things that Mr. Feldman said, and then I will go ahead and present our case in this matter. First of all, the hearing officer is an independent contractor, and he has to review it without an established record. And sometimes, in order to perform that duty, he might consult resources in that effort. And that is not improper. The Supreme Court also says that the combination of legislative, investigative, and adjudicative functions in one agency does not create an unconstitutional risk of bias in administrative adjudications, because there's a presumption of honesty and integrity in those adjudications. And that's the Withrow v. Larkin, 21 U.S. 35 and 1975. The Colorado Court of Appeals also held the principle in Meyerstein versus City of Aspen, and despite what Mr. Feldman thinks, procedural due process, the Meyerstein case found, is not violated merely because APCHA, the respondent, investigates and charges and adjudicates the claim. Each one of those functions is contained in a separate person in the agency of APCHA. And Mr. Ireland has his function, I have my function, staff has their function. And those functions were carried on separately, and there is no issue as far as that is concerned. Intellectual dishonesty, that's a little tough. Mr. Feldman was talking about my APCHA's statement in the brief that he opened the door as to Ms. Silvino's qualification. He absolutely was there. We had 2 days of hearing. He showed up on the second day of hearing. And if you go to Exhibit 4, page 328, lines 7 through 9, he states emphatically that Ms. Silvino's qualification was never at issue, and it appears that the hearing officer took that upon himself because he opened the door, and apparently the hearing officer didn't think that was, he believed that to be a statement that he wanted to address. And so I did not act dishonestly when I quoted exactly what Mr. Feldman said during the hearing. Number 3, APCHA did not know until the first day of the hearing on 9/26/2023 that Mr. Francis was actually and permanently gone from the residence. We had indications in some of her responses, particularly to the notice of investigation, wherein she said, I have recently been granted a dissolution from Mr. Francis. That wasn't true. It was pending up until, strike that. But until we got to the hearing, we didn't know that he was actually gone. We suspected it, and we asked about information, and in the NOV, through our own research, we had enough information that we felt that the pieces that trigger the deed restriction were affected, that he wasn't working full-time 1,500 hours, and he was no longer in the residence. And because of those factors, we pursued the NOV. I never, ever said, we need to win this case. I don't speak like that, and that's an inaccuracy, and she has mentioned that twice. Ms. Silvino has, and that is not true. As far as the recital being against public policy, it is absolutely enforceable. There may be fact scenarios that trigger its operation that Mr. Feldman believes are against public policy, but the intent of the restriction is reasonable, and its operation is not inherently offensive to the public. Ms. Silvino chose the real issue, excuse me, I'm very sorry. The recital in this case has two parts. What's important to remember about this case is that the standard of review for the board is based solely on the record that was before the hearing officer, and the duty today is to either affirm, modify, or reverse the decision of the hearing officer. This case isn't about divorces, length of marriage, prenuptial agreements. It's about adhering to the APCHA regulations and the operation of the deed restriction. It is an if certain events happen, then certain obligations are triggered. The deed restriction is neither complex or ambiguous, and it was enforced by APCHA in this circumstance even-handedly. Ms. Silvino acknowledged that she read and understood the deed restriction when she signed it. Essentially, it has two clauses. It explains that both buyers, and in this case, most owners of property go through the bidding and lottery process. And in this case, neither Mr. Francis or Ms. Silvino did. They were both quit-claimed onto the title of the deed. And so typically, if you do the normal way of acquiring the property, you buy it and then become owners. In this case, they became owners. I typed the deed restriction into the NOV, and I accidentally wrote the word owners the first time the word appeared in the recital, and in the second time I wrote the word buyers. It was an innocent error. There was nothing malfeasance in doing that. But in any way, the recital says either the buyer is removed from the property or is no longer in compliance with the APCHA regulations prior to the 5 years, the home will be immediately listed and sold through APCHA. With that background, the hearing officer in his findings of fact and conclusions of law stated that neither Mr. Francis nor Ms. Silvino was in compliance with the requirements of the deed restriction that they both signed. He found that neither owner has proven 9 months in 2022 residing at the property, and that they failed to support that they met the employment obligations of 1,500 hours in 2022. Whether that goes beyond the NOV is not something APCHA is going to parse out today. What's important is that there's multiple reasons for affirming the ruling of the hearing officer. First of all, the violation of the 5-year requirement in the deed restriction is alone sufficient to affirm the NOV from 2023. As of June 1st, 2022, Mr. Francis and Ms. Silvino were the title owners of the property, and they executed the deed restriction. The evidence supports that by August 19th, 2022, Mr. Francis left the property, never to return. What's also established is Mr. Francis did not work full-time 1,500 hours in 2022. That's a violation of the regulations. Both actions are in violation of the 5-year clause in Recital 6. Essentially, Recital 6 said you can either be removed from the property or you can fail to be qualified under the regulations. He hit both of them. Ms. Silvino and Mr. Francis agreed to be bound by the requirements of the operation of the deed restriction. That was part of the ownership agreement for the property. Mr. Francis' violations are final and not subject to appeal, and as such, they are sufficient to require the sale of the property at this time. The evidence also shows that Francis specifically violated the occupancy and employment requirements. I'm restating this because those features underlie the action of the 5-year clause. Not only did APCHA demonstrate that Mr. Francis failed to verify qualifications, his last pay slip was in March of 2022, didn't work the rest of that year or didn't verify any employment for the rest of 2022, and he vacated the property on August 19, 2022. That's not 9 months of 2022. Therefore, he didn't have 9 months occupying the property in 2022, and he didn't verify that he had 1,500 hours working full-time in 2022. The hearing officer found Mr. Francis did not document 1,500 hours of work in either 21 or 22, and that he didn't reside in the property for 9 months. And even counsel acknowledged in his appeal brief that there's no question that John does not live in Aspen anymore. As such, there is similarly no question that John does not qualify for APCHA. That's Exhibit 78 at page 795. So at this point, APCHA requests the board affirm the ruling of the hearing officer. Mr. Francis vacated the property and failed to remain qualified. The 5-year clause was triggered. Mr. Francis and Ms. Silvino are married. They are co-owners of the property. When that deed restriction is violated, it affects both of them. His conduct, at least in one reading of the facts, triggered the deed restriction, but they are both in violation of it because they are co-owners, both signed the property, and Ms. Silvino understood that because she testified that she read and understood what that means. If I might also add that in her testimony at, I'm sorry, I'm flipping around. If we go to Exhibit 3 at page 278, there was a discussion about with the hearing officer. And Ms. Silvino, in her statement, suggests that she understands what the operation of the deed restriction meant and asked the hearing officer to make an exception in her case. She said, "So I guess what I wanted to ask you is, this rule is very black and white, and it's a newer rule. Cindy said it was a newer rule, and maybe I thought you could put in a clause in there for situations like this, because how many of my friends of mine have not made it to 5 years, or domestic violence is not a reason to stay in a marriage for 5 years. And so maybe we could make an amendment to this rule is what I'm wishing." And I asked, "You said you understood what the deed restriction said." And Ms. Silvino replied, "I do, and that's why I'm asking kindly for an exception to this rule." Ms. Silvino understood the ramifications of this. She has been in housing for many years, and she knows how it works. She knows the importance of qualification. She understands deed restrictions, and I think she was a homeowner who made some choices that did not turn out the way she hoped they would. APCHA is in the business of trying to provide a very scarce commodity to a very expensive place in the world to live. And with that commodity, there have to be defined rules, and those are our regulations and our deed restrictions. They give notice so that people understand what is expected, and when people don't follow them, our job with APCHA is to enforce those regulations and those deed restrictions. We must do it for transparency. We must do it for integrity of the program. We have a public responsibility to our community to do that. And unfortunately, our personal lives and personal situations can complicate and put pressure on things like jobs and housing. But it's an affordable housing program with great perks for people who qualify and can be in there. We even discussed with Mimi that we are happy to try to get her back and she can apply for a rental unit again. But under the regulations and the deed restrictions, she is no longer permitted to reside in that property. She knew it going in. Circumstances happened. They happen to everybody. And in this particular case, she waited a year to tell APCHA John wasn't living in the home anymore. She might have mentioned in November of 2022 that things were bad and they were in the middle of a divorce process, but she did not indicate that he was no longer living and working in the property. She perpetrated this on and on. In April of 2023, every owner of every home needs to complete the biennial affidavit. And she and John were co-owners. The affidavit was sent to them. She said they never got it, never completed it. After the NOI, when she said she had been granted a divorce, and she said she was only providing her documents in August in response to the NOI, that John was gone and she couldn't find him. A week later, she decides to complete the biennial affidavit. And yes, it's drop-down menus because it doesn't allow you to fudge whether they are or not. She knew John wasn't in the property. She knew John wasn't working. He hadn't for a year at that point. Yet she still said in an affidavit, which is an attestation of the truth, that he was living in the property 9 or more months out of the calendar year, and that he was working full-time at least 1,500 hours. She could have checked no. Those options were available, and that was the truth. But instead, she didn't. She withheld from APCHA for a year that he was gone and not working. When she had an opportunity on this biennial affidavit to come clean, she didn't do it. She continued to perpetrate that falsehood. No one is going to judge why she did it. Sounds like a personally downtime for her. But what we are going to do is hold her to the words and what she does say, because we have rules and regulations. We need to work in the black and the white, not the emotions. And based on that, the hearing officer came to the right decision. The recital 6 was triggered. The 5-year restriction wherein both parties needed to remain in the property, on the deed, and under the regulations in terms of qualification to be a qualified owner of the property. The hearing officer is correct. Those were not met, and his decision that the operation of the deed restriction must go into effect. And the remaining part of that is that the property must be listed for sale. It's a consequence-neutral deed restriction. If this happens, then we must sell the property, and that's where we are. So APCHA requests the board affirm the hearing officer that the property must be listed for sale, and Ms. Silvino is responsible for the fines that were outlined in the 2023 NOV. Thank you.
We've got about 10 minutes remaining. Okay, Mr. Feldman.
Sure.
you've got 8.5.
Mr.
Mr. Feldman, you've got 8.5 minutes.
I'll try not to take that much.
Okay.
The first point of rebuttal is, Meyerstein, the case law, Miss Marinaro is not an attorney. She should not be providing you legal advice. She should not be interpreting case law and telling you what she thinks it means. She's not a licensed attorney. Putting that aside, Mr. Ireland doesn't work for APCHA. He's not a committee. He's not a part of the agency. He's an independent that you bring in to resolve a dispute. He doesn't work for APCHA. He can't be, and he's not an employee. It says that in the regulations. He can't be, right? But he's supposed to be completely independent. He's not allowed to work with APCHA to put together a prosecution of Mimi. Yet that's exactly what he did. This notion that I opened the door, again, it's intellectually dishonest. Mr. Ireland was asking and demanding documents from Mimi, her divorce proceeding, her tax records, emails, everything, at the September hearing. I wasn't there. The reason why I was brought in is because my client was scared to death about what happened and why Mr. Ireland was acting the way he did. So then she found me to help her as an attorney. I didn't open the door to anything. And APCHA knows that. APCHA was informed directly in October of 2022 that John Francis didn't live there. Despite everything she kept going on and on about, it's in the record. October 15th, email to Bethany. I'm not recalling seeing that APCHA found that John Francis didn't qualify. But we're not here to discuss John Francis. We know he doesn't qualify. We know he doesn't live there anymore. We don't have to belabor that point anymore. The question is this recital to a deed restriction enforceable? And I think that that's going to have to be a discussion you have with Tom as APCHA's lawyer. Ms. Marinaro is not a lawyer, despite being introduced to me as a lawyer, and despite Mr. Ireland referring to her as APCHA's counsel. Right? She's not a lawyer. That's why you're not hearing anything about APCHA's position on whether or not the deed restriction, the recital in the deed restriction, is enforceable by virtue of it only being a recital and by virtue of its unconscionability and as against public policy. Mimi's understanding about the recital, I touched on this before, but maybe for a minute, doesn't matter, right? People hire lawyers to help them with interpretations of business deals. Okay, they signed a contract, but there's as an example, there's a contract, an advance contract, an acquisition of a publicly traded company, right? The executive director, whoever signs it, but inside the 6,000 pages in that deal, there's a contract term that's blatantly unenforceable. Just by virtue of the signing of that contract in that case, that doesn't waive anyone's claim that the provision in the contract is unenforceable. That's not a correct statement of the law. Yes, Mimi signed it, but she wasn't aware that it's totally unenforceable. And into that, there is not a regulation in the 2021 regulations, which are operative here, or even in the 2022s or the 2023s, that support that recital. And that's an important point. I raise it in my brief. APCHA cannot start inserting clauses into deed restrictions that are not in strict accordance with an existing regulation. If APCHA could do that, it could be very well argued that the regulations are meaningless. Because if APCHA can insert something in a deed restriction, right, and it's not supported by the regulations, then what the regulations are not relevant to anything. And it's also not proper to have a deed restriction that says that the deed restriction is going to can be updated by future versions of the regulations. You can't change something that's on title by something that's off title. And that may be a side note that maybe you guys have discussed, I don't know, but certainly that's an issue.
About 3 minutes.
Cool. Mimi's been in housing for years, as I said. She's always qualified. She's never not qualified. APCHA has never determined she was not qualified at any point in her relationship with APCHA. The only person that has ever said as much is Mick Ireland. Mick Ireland was never asked to answer the question of whether Mimi was qualified or not. He did it on his own. And that's proof positive of his conflict of interest and his ultra vires, or acting outside of the scope. The hearing officer's the hearing officer's duties are defined in that section, Article 6. You know it. It's somewhere down there, right? He's to enforce the regulations and nothing more. I've got more, but I think I've belabored a point. I think I've talked to you guys long enough. I thank you so much for listening to me. And I'm here to answer any questions you may have. And yeah, Mimi, on behalf of Mimi, we thank you very much ahead of time for a fair hearing. Appreciate it.
Thank you. Just Tom, procedurally, does staff have, or is that, do you feel like you need to?
No, I think
No.
between
Okay.
the brief and
Great.
and today we're fine. Thank you.
Okay. Any clarifying questions from the board? Again, so any questions would need to be like a clarification or a request to direct to something in the record, just in order to ensure that we're considering the evidence that was presented to the hearing officer. So with that, I'll open it up to the board. Board?
Yeah, I have a question. Exhibit 9, page 370, the 5-year clause, is that in all the deed restrictions?
No, it wouldn't be in all deed restrictions. And I'm not aware of all deed restrictions, but I don't believe it would be in all of our deed restrictions, no.
Is it unique to this deed restriction?
No, it's not unique to this deed restriction. And it is supported in the regulations. If you go to Part 6.
Broad clause.
Yeah, there's I'm so sorry. It's not unique to this deed restriction, and I was just looking for it because I thought it might come up.
Do you have the site on that?
In Part 6, under maintaining ownership, I will get you this citation here.
Just page number. And just for point of quality.
It is in the regulations, under Section 3, owner's responsibility, B, on point number 2, it says where one or more co-owners of a 2 or 3 bedroom unit vacates the unit within 4 years from the date of purchase, the unit must be sold in accordance with the applicable deed restriction unless a court order requires such. We have regulations and rules because this situation can come up, and it is not specifically aimed at any particular person. It is just a situation, and we needed to deal with it, and so we regulated on it, and that regulation just got carried over to the recitals in this particular, but in this deed restriction we're talking about today.
Could you please cite the page for that APCHA regulation? What page, is that on page 17?
It's on, excuse me, it's on page 46 of the APCHA regulations, and I'm trying to find the page in the exact packet for you.
We didn't cite all the regulations in the packet. We sort of left them as judicial notice. I provided 2 of the sections that we relied on in the notice of violation. But this is more of a rebuttal to something that Mr. Feldman raised, so it isn't in the packet.
May I just,
Quickly.
which version of the regulations are you looking at, Bethany?
I'm looking at both the 2021 and the current regulations, because you brought up 2021,
Yeah,
so.
I'm on page 46 of the 2021s, and I'm not seeing where you're,
The 41 was the current, so 1 second and let me, then 2021, it's on page 41, number 2, B2. Under maintaining ownership qualification, where 1 or more co-owners of a 2 or 3 bedroom unit vacates the unit within 4 years from the date of purchase, the unit must be sold in accordance with the applicable deed restriction unless a court order requires such. So it's the same wording
yeah, I
as
see it.
in the current.
May I have a chance to respond to Mr. Hohenstein? First of all, this is not applicable. Mr. Francis purchased the unit in 2002 or 2005. I forgot which time. Right? This is for someone who buys something. 2 people buy something, and then within 4 years, one person vamooses for any number of reasons. Then the other person has to sell it. It does not apply to Mr. Francis. He's owned that property for 20 years before this all started. And 2, obviously, this has a 4-year restriction. Now, we have a 5-year restriction, so that's different. So it's not supported by the regulations, regardless of what APCHA argues. Okay? It's similar, but it's not supported. 2, that provision is void against public policy too. I mean, so 2 people, co-tenants, and they buy an apartment. I've said this before. And in the 2nd year, one of the co-tenants tries to kill the other guy. And he gets thrown in jail. The victim loses his housing. I mean, you can't possibly take that position. That's inhumane. Thank you.
Thank you.
May I just
Any
clarify?
other? Go ahead.
Oh, okay.
Any other questions?
Yeah, is there a precedent for violation of that 4-year clause in the rules or the 5-year clause in this deed restriction where people have been forced to sell their units?
I can't answer that just because of my limited history with APCHA.
I don't think there has been a.
We're outside the record, I think.
Okay. Thank you both. Thank you.
Thank you.
Thank you, sir.
What happens next?
With that, we will bring this to the board for discussion. We've got noticed an executive session. Does anyone feel that we need to go into executive session for legal advice from Tom? I mean, I would make.
I'm
that motion.
recommending it, but it's not my decision.
Yeah. So, I would make a motion to go into executive session for a conference with APCHA attorney for the purpose of receiving legal advice under C.R.S. section 24-6-4024B regarding the appeal by Miriam Silvino.
I second, and for the purposes of the, for Mr. Feldman and Miriam, can you explain who will be in that session?
Sure.
So they understand.
I think in order to ensure the integrity of the process, there shouldn't be anybody in the room but me and the members of the board.
Okay.
And could I just,
The related question is whether or not you're going to want to deliberate after executive session, because that affects
Right.
whether the appellant and her attorney want to hang around or not. So as a matter of courtesy, it would be good to address that. My recommendation would be, and again, it's a board decision, that deliberations occur at the next meeting, so that over the next 2 weeks you have a chance to consider everything in the record, the arguments of the staff and Mr. Feldman, and also the legal advice that you'll get from me. That would be my recommendation.
Okay. Thoughts on that?
Yeah, I'd like to have an opportunity and the time to grok this, to more fully understand it, and to digest the legal advice that we're getting from our
Okay.
attorney.
All right, so we're going to executive.
Still need, has there been a vote on that?
So we've got a,
Moving on to
we-
exec.
Did
We've
you
got a-
vote on the motion to go into?
we've got a
executive?
motion on the table right now, so there's not been a vote. But prior to going into executive session, so we're going to executive session, we'll come out of executive session. There will be no further agenda items. We will conclude the meeting and we will move the deliberation to the next regularly scheduled meeting, which I believe is 21st.
And the record should reflect that as in accordance with the open meetings law, since the purpose of the executive session is solely for legal advice, doesn't need to be recorded.
Okay.
Can I just ask that we make sure that we're copied on the agenda and the notice of the next meeting?
Absolutely.
For sure.
We'll make sure.
Thank you so much. Appreciate it. I think we're done here, right?
Thank you very much.
Thank you.
Okay, so we have a motion to go into executive session on the table, and it is a roll call vote.
Okay.
Second.
She did.
Kelly seconded.
Kelly,
Yes.
Peter,
You're not on,
did he get
Didn't hear you,
yes?
Peter.
Peter, did you say yes? Peter, can you hear us?
Hold on, give him a second.
Swapping it out.
can you let them know we're not hearing them, or?
Peter, we cannot hear you.
He's working on it. He just pulled it
Oh,
back.
yes, sorry.
Okay, okay, okay. Carson,
Yes.
Ward.
Yes.
Okay, we'll take a short break to clear the room, and it will only be Tom and the members of the board in executive
You
session.
guys can go. I